The Honorables, presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court.
Judge Stroud, would you like me to go ahead and proceed? I'm sorry.
Can you hear me now? Okay, I'm sorry. My audio disappeared when we went live, and I don't know why. But anyway, I've been playing with it, and I believe I have it back on now. Is that correct?
Yes.
All right. Did Dan open court already? Okay, because I couldn't hear any of that. So, all right. Sorry about that. My first WebEx argument and my computer's first WebEx argument. So there. Okay. Well, we are ready now, I believe, and everybody can hear, right? For our argument in the Sherrill v. Sherrill case. And so we will proceed with that and with Ms. Cannell for the appellant.
Thank you, Your Honor. Judges Stroud, Murphy, and Brooke, first of all, thank you for taking this time for this very important argument to my client. My name is Michelle Connell. May it please the court. I represent the defendant mother, Linda Hunter Sherrill Burlington. I probably will refer to her as Mother or Miss Sherrill. And just to confirm, can everyone hear me okay? And I have already spoken with Mr. Horn about reserving 5 minutes. So I think we're locked and loaded on that. This case is about a parent's constitutionally protected right to the care, control, and custody of her child. And I'd like to just start by previewing the points that I'd like to make during the argument, and then I'll move on to a brief rendition of what the facts are that I believe are important. First of all, that I'd like to address is that the natural parents have a constitutionally protected paramount right to the custody, care, and control of their children. And to establish this, I'm going to rely heavily on the case of Troxel versus Grandville, which is a United States Supreme Court. And that case essentially states that the Due Process Clause does not permit a state to infringe on the fundamental right of parents to make child rearing decisions simply because a state judge believes that a better decision could be made. And also in that case, it states that the liberty of interest of parents in the care, custody, and control of their children is perhaps the oldest and most fundamental liberty interest recognized by the United States Supreme Court. So that's point number one. The second issue that I'd like to address is our statute, North Carolina General Statute 50-13.1, 5I. And that states that prior to denying a parent the right of reasonable visitation, the trial judge shall make written findings of fact that the parent being denied visitation is an unfit person to have visitation with the child, or that such visitation rights are not in the best interest of the child. The third point that I want to address is the punitive nature of this custody issue on appeal. Essentially, this order is a termination of parental rights order. It is impossible for Ms. Sherrill to get out from under this by simply filing a motion to modify custody because there's no way to prove that there has been a substantial change of circumstances that have occurred based on the findings of fact, the conclusions of law, and the decree of this order, because it is in fact a termination of parental rights order. And finally, I want to discuss how the findings of fact do not support the conclusions of law in this case. And generally, to overview that, the issue there is whether there are a waiver of the findings of fact and the responsibility of the trial judge to protect the integrity of the court order by having, if the decision is to have a secret chambers type hearing, what is required of the judge then in the order. So with that as the background, I'd like to just take a quick look at the timeline of the case. And I believe that we could sort of base it, the beginning point in this case on November 26, 2016. That was a weekend of Thanksgiving weekend that weekend. Miss Sherrill works at Honey Baked Ham. She had worked very long hours during that Thanksgiving weekend. It was a Saturday morning. She was not feeling well. She was extremely tired and she fell back asleep in bed. And she was awoken by the minor child who climbed in bed with her with some food to watch TV. At the time, he was wearing pajamas or perhaps sweatpants. It's something she couldn't quite remember. And he was lying under the comforter. Miss Sherrill was groggy. She went to pet either a pet cat or a pet dog. And instead, she put her hand on the genital area on the comforter, but in the general area of the minor child's genitals. She immediately pulled her hand back and she said, "Whoops." The minor child laughed. He did not seem embarrassed and he did not scream. Ms. Sherrill then fell back asleep. The minor child finished eating or watching TV and then left the room. The incident was never, and I'm going to refer to it as an incident, but the incident was never again discussed or brought up until 5 months later at the first secret chambers meeting. The next significant event is March 25th, 2017, which was when the parties separated. That's the date of separation. Mother at that time left the marital residence and father remained in the marital residence with the minor child. 12 days later, father filed a motion for ex parte temporary custody to maintain status quo. And that ex parte motion did not mention, it was based on the fact that there was concern that mother had said that she's going to take the minor child and father would never see the child again, that father was afraid that mother would take the child from school or from the residence, and that ostensibly the minor child said that he was afraid that mother was going to take him and not return him to his father. There was no mention in that ex parte order about a sexual touching or about the incident. There was no allegations of substantial risk of harm in that ex parte order. April 7th, that ex parte motion. On April 7th, 2017, the ex parte order was entered. There are no findings of fact, and the only things that it states is that father should have legal and physical custody of the son. That's it. On April 18, 2017, the temporary custody order was entered after a chambers hearing that was secretive. The parties were not present. The minor child was there with the attorneys and the judge. This temporary order also does not have any findings of fact. It only states that father gets full custody, full legal custody, and full physical custody of the child. After this first secret chambers hearing was the first that anyone learned of the events on November 26, 2016.
And to clarify real quick, that was a different judge than the judge that hears the final permanent custody hearing, correct?
Your Honor, I believe it's the same judge. I think it's Judge Pickett.
Okay.
Yes, sir. And the reason that we know that this is the first time that the incident was discussed was because the order on appeal now actually states in its findings of fact, you can see this on the record on appeal, pages 89 and 80, that findings of fact 19 and 36 state that this is the first time that this was recorded. So it's a little confusing how a first secretive chambers hearing was then used to make a finding of fact in the permanent custody order, especially when temporary custody order should have been non-presidential. But nevertheless, it shows up again without any findings of fact or any basis in the evidence in the permanent order. As a result of that initial hearing in chambers that the parties were not privy to, the report was made to law enforcement, and it was also made to the Rowan Department of Social Services. Now, from that time, between the time that initial secret chambers hearing occurred and the permanent child support trial was held, I think it's about 11 months, there was a full police investigation into the issue. Mother fully cooperated. She gave a complete statement to the police. As a result, no criminal charges were filed. The district attorney declined to prosecute the case. Department of Social Services did 2 investigations. The first investigation turned up, again, mother fully cooperated with both investigations and gave full testimony or statements about the incident. And the first investigation ended with a letter in June of 2017, and it was the allegations were unsubstantiated. The second investigation was concluded in October of 2017, and that also was unsubstantiated. There have never been any juvenile neglect or abuse proceedings that were initiated by Department of Social Services. There has never been a domestic violence protective order filed by the father on behalf of the child to protect him as a result of these incidents. Which leads us to the first point that I came to. Due process clause does not permit a state to infringe on the fundamental right of a parent to make child rearing decisions simply because a state judge believes that a better decision could be made. In March of 2018, it was March, the end of March, like March 20th, 22nd, and then it finished in April 4th. The custody trial was held during that time. This was approximately 1 year after the original ex parte order was entered. So this is approximately 1 year after the minor child has been solely with father. Mother had had no access to him whatsoever in any form or fashion. And she had gone through all these investigations with the police and DSS. The permanent custody order was entered 8 months later. So another 19 months passed, but the permanent custody order was entered December 20th, 2018. And that permanent custody order, which is on appeal now, concluded as a matter of law, and this is on the record, page 93, that the defendant, the mother, is not a fit and proper person to have custody of the minor child and is not the best interest of the minor child for his custody to be with defendant. And in addition to that, conclusion of law number 5 states that the defendant is not a fit and proper person to have visitation with the minor child and is not in the best interest of the minor child to have visitation with the defendant. And these are in fact the conclusions of law. These are not part of the findings of fact, which we'll discuss in just a moment.
Counsel,
We know from
Counsel, can you remind us in regards to that permanent order of the scope of the restrictions that are placed upon the mother in this instance?
Those are the restrictions.
In regards to her interactions with her son, can you remind us of the scope of those restrictions?
Yes, sir. The court went on to decree, and I believe this answers your question, that the defendant, Linda Sherrill, shall not have visitation with the minor child at this time. And that was it as far as the decretal portion of the order. That's on the record, page 93.
Were there also restrictions put in place in regards to her access to records of the child as well? Am I misremembering that?
Well, Your Honor, she was given full legal custody of the minor child, or excuse me, the father was given full legal custody of the minor child. So she did not have legal custody in order to access the education or medical records of the child.
And ask, there's a finding of fact about sending letters and gifts when knew that the minor child didn't want her to. would it be your position that this order prevents her from being able to send letters and gifts to the minor child to foster that relationship, given how it's kind of passively looked at as a negative in the findings of fact?
It, it, I do not believe that under legal custody or physical custody that is prevented from her from reaching out, Your Honor. I do think the problem is that she would have to know where the child is in order to make any kind of outreach to that effect. And under this order, she's not entitled to know that. And that leads us to where we are in Troxel, that, you know, parents are presumed to be fit to act in the best interest of the minor child.
Counsel, I understand your argument, and your argument is that this is functionally equivalent to a termination of
Yes, sir.
parental rights. And I understand the rooting that has in Moore and the progeny that has sort of flowed forth subsequent to Moore. Obviously, there's quite a debate about Moore and whether it remains good law at our court. But let's assume, for the sake of argument, that it does not remain good law at our court, and that this is not the functional equivalent of a termination of parental.
Okay.
But instead, and heaven knows that I'm probably butchering some of the names here in these cases, so I apologize if I am doing that. But instead, that the standards that were articulated by our court in Restus are applicable and govern in this circumstance. Can you talk a little bit about how can you win under the standards articulated by our court in Restus? And if so, can you talk to me about how you would win under those standards? And I understand that you disagree with how I have framed that, and I understand the argument in regards to Moore and its progeny. But setting that aside for the moment, can you talk about what your argument would be, if you have an argument, per Restus in cases that are in accord with you?
Okay, yes, sir. And I would address that in two ways. And the first way is a little bit more superficial, but I think it's sort of there's not a whole lot of wiggle room with this position. And that would be if you're looking at it just under 50-13.5I, which specifically addresses visitation of a minor child. And it states that in order for a court to deny reasonable visitation, the trial judge shall make written findings of fact that the parent's either unfit or that it is visitation rights are not in the best interest of the minor child. And so in this case, Your Honor, if you look at the order, there are absolutely no findings of fact that Ms. Sherrill is an unfit mother. There are absolutely no findings of fact that she has acted inconsistent with her constitutional rights. No findings of fact that she has neglected the welfare of the child, which is what's required under Adams and Tessmer, or talked about in Adams v. Tessmer. There are no findings that the visitation is not in the best interest of the minor child, and that goes to what Restus required. In fact, Restus actually states that the statute could not be more straightforward or unambiguous. I think of the words exactly in Restus. And so the order must contain these findings of fact, which are not in the order. And by virtue of that, the order should be reversed for those failures alone.
So I assume that what we're going to hear from the other side is that the conduct that you mentioned previously that occurred on this morning, where there was unintentional touching of genitals that occurred here, and that the broader sort of conduct of the mother in this instance in regards to, I think, a 12-year-old child sleeping in the mother's bed. I assume that what we're going to hear from the other side is that those findings go towards and would support a finding that that visitation is not in the best interest. Is your argument that we just really haven't bridged the gap here, that the order needs to more fully explain itself in regards to why this instance or these arguably sort of a troubling pattern are inconsistent with visitation for respite? Is that the crux of your argument?
That's the crux of that. I sorry, did I interrupt you?
No,
That particular office argument, because Your Honor, we all understand that if that's the whole argument, it goes back down and the trial court makes a finding of fact that the mother's unfit, and we're done. And this goes beyond that. And the reason this goes beyond that is because there is such, in order, in the cases cited in the Pilley's brief and as well as mine, the cases, the Hummel case, for instance, which I believe Judge Stroud authored, that was a situation where there was a series of, dad was denied visitation. There was a series of orders that were entered that again and again and again gave father the opportunity to correct everything he was doing wrong. And then finally the court said, no, you have lost your right to visitation. The Respite case, that was a case in which father was convicted of, I believe, 9 felony counts of indecency with a minor. And the Rutan case, and again, I'm not sure if I'm butchering that or not, that is a case that talks about where biological mom's constitutional rights were violated because there were no findings of fact that it had been what she had done was inconsistent with her right as a parent. And Your Honor, it goes deeper than an evidentiary, or excuse me, an ultimate finding of fact that that she's unfit. Yes, sir.
Let's assume that, I want you to assume 2 things for this next question. One is that we find that the findings, even though they're in the conclusions of law, are enough to be an ultimate finding, and for the technical reasons, we're okay with that. Let's then assume also that I agree with you that there's not enough to support a finding of being unfit. Tell me how you get around the finding of the best interest of the child. That seems to be much more in the discretion of the trial court in its findings of fact. So putting aside the unfit part of 55I, get me there to the best interest prong.
And you're correct. This is it's a original permanent custody, so it is based on the best interest of the child, and that would be at the judge's discretion. However, this court reviews de novo the conclusions of law, and so in this particular case, the findings of fact don't support that conclusion of laws that it is in the best interest of the child. And Your Honor, I would go back to the fact that there is nothing in these findings that would suggest that she has acted inconsistently with her parental rights. And that, and I know I keep going back to that, but it is, I would say that it is abuse of discretion. When this mother, throughout this whole child's life, until this last 6 months prior to the date of separation, did everything for this child. Handled his educational needs. She started a 529 plan. She took care of him. The father, yes, Judge Stroud.
Let me ask sort of about the maybe the elephant in the room that I'm sure we're going to hear about from Mr. McDonald. So we've got the issue, of course, of the son talking to the judge in chambers. And the parties agreed to that being off the record. So we have no record of what the child said. And so, how would let's say we were to remand to the trial court for findings, in more detail about why this happened. And the trial court were to find that maybe that the mother touched the son in a worse manner than on top of the comforter, on top of his clothing, in a manner that would actually be a crime. We don't have a record of what happened in chambers, so there would not really be any way for us to address that if that were to happen and it were to come back on appeal again. How do we? What is Is that a problem?
Well, it's a problem. And what I would say to that, first of all, this is analogous to the Moore case in the fact that in both this case and the Moore case, mother was fully investigated. And so for the trial court to then come and find that a crime has occurred after the police had cleared her, after the DA said that there's nothing to prosecute, after the Department of Social Services did 2 full investigations, for the trial court to state that there was a crime or that there was something happened, I believe this would be contrary to any evidence. And with respect to the Chambers hearing, what the trial judge said was that the party stipulated that specific findings of facts are waived and confidential. But that doesn't alleviate the court from making ultimate findings of fact in this case. And this particular order is devoid of any kind of indication that this child, what he testified to. And to that point, we don't even know if the child was sworn in. The court talks about that we didn't want him to feel like he was in the middle of this custody abuse. All the other witnesses before they testify says having first been duly sworn. We don't know that the child was under oath.
Well, wouldn't that be something that the parties would have waived? Basically, if the attorney stipulated you can talk to the child in chambers and didn't stipulate as part of the term of that the child has to be under oath or whatever, would that matter?
Yeah, I think that would need to be made clear. I think that what exactly was being discussed back there and how it was being discussed it does go to the crux of the argument. There's no findings of fact.
But I mean, finding of fact 36 and finding of fact 41 do give some indication of what the minor said. I think 36 says while trying chambers with both attorneys present, the minor child disclosed that his mother had touched him inappropriately, and in 41, and this is in reference not really to the testimony, but of the referral to the therapist that occurred here, that the child's mother had touched his penis. So I mean, the idea that it's entirely a black box, what was said by the child, I think that's a little bit overselling the point, but that doesn't necessarily mean that all of the problems are solved here or that the ultimate conclusions are supported by what was found in the record.
There is a problem to the extent, Your Honor, that, I mean, part of the reason, and just to back up, and I'm running into my 5 minutes rebuttal, so I'm going to talk fast, that is that a child, okay, reasons that child judges don't talk to children is because they're susceptible to being coached, or they want to live with Disney World dad. In this case, the minor son had been with his dad for approximately a year when he testified with the judges and with the judge and the attorneys. And there's nothing in the findings of fact to alleviate that this was credible evidence. And so I think that goes to the weight of the evidence. When all the investigations said one thing, and then this one impressionable minor child has stated that, if you look at page number 36, that he had been touched inappropriately. And so, again, I think that the weight of that in this type of situation is so critical, that since there were no no ultimate findings of fact that would protect this order, the integrity of the order, and that was incumbent upon the trial judge to do that, it did not rise to even meet any kind of abuse of discretion findings. Yes, sir.
Real quick, just before you sit down. So in your brief, you have not argued that 35 and 36 weren't supported by competent evidence, correct? You didn't challenge those 2 findings specifically, correct?
I did challenge, yes, sir. I did challenge 35 and 36.
You did challenge 35. And then looking at the record, pages 30 and 93, going back to my question when we opened, it looked like it was Judge Marshall Bickett that heard everything in chambers in 2017, and then Chief Judge Brown.
Yes, I'm so sorry.
90. So there's nothing in the record that we can point to that of what the substance of the conversations in 35 and 36 were, correct?
You're correct, sir. Thank you for correcting me. I'm going to take 1 minute to say this about this order. In order to modify it, Ms. Sherrill would have to file a motion to modify, to prove a substantial change of circumstances that affected the welfare of the child and that it's in the child's best interest to change custody. And the reason that that's an impossibility in this case is, one, the findings of fact are clear, as are vague. As it pertains to Ms. Sherrill, it's nothing in the order that she can look at and say, this is what I changed. I was a drug addict, now I'm not. I had mental health issues, I went to counseling. I was in a domestic violence home, and now I'm out of it. There's nothing she can prove to show that there's a substantial change of circumstances.
Which is quite a distinction from Hummel, which you referenced previously.
Yes, sir.
But as Judge Stroud repeatedly highlighted,
Exactly.
time and time again, efforts to say this is a way of righting the situation, and instead of doing that, that is further entrenched.
That's exactly
Not
right.
really distinguishing, right?
Yes, sir. With regard to the son, she doesn't know or have a right to know where he is or how he is or what his safety is, how he's doing in school. She doesn't have access to his education or his medical records. She has no way to prove a substantial change of circumstances. And that is a major flaw in this order, Your Honor, because she cannot get out from under it. I have 54 seconds left, so I'm
going to give you an additional 4 minutes on rebuttal since we asked a lot of questions in this weird setting on WebEx. So
you're kind. Thank you, Your Honor.
Fix that for us. All right, thank you.
Thank you.
And if you'll mute yours, and now we will move to Mr. McDonald for the father appellee.
Thank you very much. If it please the court, David McDonald on behalf of the plaintiff and the appellee, Jay Sherrill here. I think it's important to recognize that Mrs. Sherrill has attacked this order on 2 grounds, neither one of which is sound. The first of those is that the trial court did not follow Moore. And I think I have extensively dealt with in re civil penalty and the effect of the number of decisions that have followed Moore in the brief, and I will simply request questions if there are any clarifying issues about that.
Mr. McDonald, can I start there and start a little bit about where your opposing counsel left off in regards to that question right there? So first, thank you for taking this case. We're all very, very appreciative for you taking this case and arguing it very, very well. Your points in your brief about how this is distinguishable from a termination of parental rights circumstance are very well taken, and to me, you don't need to belabor those points going forward. But I do have a question about what was just said by opposing counsel, because I think it is a fair question, which is, what is the way back here for mother? You know, the idea that we can, and what makes custody orders different than termination of parental rights, is that they can be modified, right? As opposed to a TPR, you're done, right? But to her point, and I think this point is well taken, if someone has a challenge with substance abuse, and the order says, you know, this is a problem, this is a problem, remedial steps have not been taken, here are what remedial steps might look like. It's a little bit harder for me to figure out, to her point, what are the remedial steps that would allow her visitation, even supervised visitation, with her child. I do think that there is a fair argument being made about how does one go about modifying an order such as this one. We're arguing for a modification of an order such as this.
Thank you very much, Your Honor. Let me begin by saying one of the circumstances that might call for this that would not be difficult for her to show would be a material change in circumstances were to be if Mr. Sherrill died. If he died, then she would be the remaining natural parent.
But she would obviously have custody if he died, but what would a material change of circumstances be, I think is the question. I mean, what could she do to fix whatever it is? Well, let's assume that one inappropriate touching, whatever inappropriate touching is, and we can talk about that later, but assume that one inappropriate touching happened, what does she do to change this?
Well, you're right. The problem with this is that, and it's really, I think it derives from the stipulation that the parties entered into, which is that we don't have and have no access to the testimony of the child. And this was because both parents stipulated to that effect. Now, we don't know what that child testified about and how.
And I understand we don't know what he said, but like I said, we have a finding that says that she touched the child inappropriately, and she acknowledged, she discussed what she said happened. So, and that's, and correct me if I'm wrong, if there's something else in here that this is based upon, I need to know what it is, because that's the main thing, it looks like. There was no history of this. There's no findings that there was a history of sexual abuse, that there was any sort of abuse of any sort going on. So assuming that there is one incident that is noted as an inappropriate touching, what does she do to undo that?
Well, first of all, I don't think it's fair to assume that there was only one incident of that. The record and the order both detail that there was a history where the child was sleeping with her virtually every night.
Well, there was a DSS, 2 DSS investigations and law enforcement investigations. So presumably if they had found any history of anything additional or anything more serious, they would have done something about it. So where do we get the idea that anything, they had obviously parents differ a lot on whether you sleep with children, how long you sleep with children. We see lots of cases where parents have that debate and people have very strong different feelings about it. But based on the order that we have, even assuming every single bit of it is supported by the evidence, how would she ever modify? What would she do to change things?
Well, and I agree, Your Honor, that this was a strong order. And the judge is presumed to have acted on the basis of substantial evidence. And that is the presumption that the Court of Appeals must follow through with. And so that any findings of fact that the judge makes, even if it's not detailed with specifics, it is incumbent upon the appellant to show error. And she has not done so. Now,
but I still think that the question remains here. I think Judge Schottmeyer are pushing you for the same thing, which is, listen, and even sort of viewing the order in the most ominous and troubling light. There's reference to some comments. There's a finding about what I'll call sort of a puberty comment by the mother about the child that seems susceptible to multiple interpretations. But even saying that it's part of a context of a pattern of inappropriate behavior, which, would be sort of the most ominous way of viewing the order. I still think the question remains, what does, how does the mother work her way back from this with this order? What does a modification look like? What does it focus on? I'm still struggling with that.
Well, Your Honor, I'm not sure that Chapter 50 entitles her to a pathway back. I don't see where the law requires that she have that avenue available to her if the judge does not believe that it's necessary and is not entitled to grant it to her. But I will note that one of the things that she did in the trial court, yes, Your Honor.
Go ahead and finish your thought. I'll wait till you're done and then I'll ask my question.
All right, and it is that her trial counsel submitted extensive proposed findings of fact, And at no point in any of this did she ever request that the disposition be different. And most of the proposed findings of fact that she presented were adopted by the court and are present in the order. She didn't ask for a pathway back. She didn't ask for the court to reconsider the motion.
Mr. McDonald, actually, this is actually brought up a question I wanted to ask, which you might consider to be sort of out of the path here. But I thought it was interesting that in the record there was a motion. There was a motion to file proposed findings of fact, and I was just curious as to why would anyone ever need to file a motion asking the court to file proposed findings? Because I mean, typically, I think attorneys do submit often proposed findings. I always appreciated it as a trial judge. And I'm wondering if that's local practice. And my ulterior motive, I'll tell you, is that we're in the process right now of configuring the e-filing system for the state. And so we're trying to configure it to allow all the things that happen across the state. And I'm just wondering, is this a local practice that happens there? Or if you know, and you may not. So like I said, that's sort of an off-the-wall question, but I was curious.
Well, Your Honor, I can tell you that I do not know. I was not trial counsel. I have consulted with trial counsel who've been very cooperative with me about this. We did not discuss why they did that.
Okay.
We did discuss the fact of it and how long it took to have that come forward, because that delayed the entry of the order for a good long while. But as far as I know, proposed findings of fact are not a motion and they're not an order or anything else like this. And I presume that the only thing that I can conclude from that is that they filed the motion in order to have a record of the requested findings of fact for review on appeal. Because like discovery, you can't file discovery without an order from the court. And that's what I presume that was to be. Yes, Your Honor.
What isn't your suggestion that there's some type of burden on the appellant to do anything kind of disregarded or trumped by Rule 52C, which says, you know, they can file these motions, but doesn't replace the ability to raise it on appeal. So am I missing something in your waiver preservation argument that goes beyond what I'm reading in 52C? I just want to parse that out just a little bit more, if you can kind of break that down for me.
Well, I think Rule 52C deals with, I think, something different from preserving a record on appeal for review. Here, she did everything that she could do, I believe, in the trial court to preserve whatever issues that she wanted to issue. And I think the Court of Appeals is bound by the record and can't ask for new evidence or something to go beyond the record in the case, and probably shouldn't be speculating about what other evidence might have been presented or the motives of the parties or their counsel in the trial below.
Does a party have the ability to stipulate that these findings don't appear in the record? You know, Judge Stroud and I were on a panel 1.5 years ago regarding Fayetteville Observer, I believe it was, about what should and should not be available for public inspection. And although there are protections for juveniles in these type of cases, by not including them at all in the record, isn't the trial court going around the statutory mandate and allowing the parties to dictate what becomes a part of the public record?
Well, there is the overall principle of a case which, or of jurisprudence really, which is that the case belongs to the parties, and that the court cannot sua sponte create issues and create an appeal for a party.
Well, Mr. McDonald, if I could just, yeah, the case does belong to the parties, but I think in the instance of child custody, the trial court always has the obligation to look out for the best interest of the children and, of course, statutory obligations to make findings of fact. So certainly in some circumstances, you can waive all findings and just not have anything there. But this was not a waiver of findings. I think this was a waiver of, it appears to me, obviously having that child's testimony on the record, and certainly having the trial court to make any sort of, which it wouldn't be appropriate to make a finding that was a recitation of evidence anyway, but, you know, not to have the trial court find that, you know, the child told me that X, you know, that would be inappropriate anyway. But to make an ultimate, finding of fact based upon what the child said, you know, such as, and could even mention that it was based upon what the child said, so we would know that it was based on that. You know, that, for example, based upon what the child said, the court has determined that it would cause the child great emotional distress and is therefore not in the child's best interest to have visitation with the mother. And we don't know exactly why that is and the details of what the child said, but we do know then it was based on what the child told the judge. So,
Well, Your
something
Honor,
like that.
I certainly understand that we're all at a loss because the record isn't preserved that way, but the parties had a very good reason for not, for this stipulation. And I suppose if I were in that position, I might consider it as well, which is to protect the child. And they did that. And at the point after that the judge revealed his ruling on the matter, and I think it would have been incumbent upon Mrs. Sherrill, if she wanted to say, wait a minute, I had no idea, I didn't see this coming, then she could have then said, Judge, we need to revisit the stipulation here and ask for changed circumstances. We went into this thinking that it was nothing but a custody case. I didn't expect that I would be denied visitation, and I believe that the court's wrong about this. I'd like to revisit the stipulation and ask the court to make findings about this. But even so, she didn't even ask the court to address the testimony of the child when she requested findings. And but she did go to the trouble to lay out on the record what her objections were, and that was not among them. So in some sense, I think that this is the court creating an appeal for her. Go ahead.
I wanted to circle back. Go ahead, Judge Brooke. Looks like you had a follow up on that.
Yeah, I mean, I understand the point you're making, Mr. McDonald, but the interests here aren't only the party's interest. We're tasked with trying to review a record that we're not in, as I said to opposing counsel, we're not entirely flying blind, but as Judge Stroud just indicated, we are in a situation where we don't have what is obviously centrally important, any sort of idea of the central testimony here that seems to have played a huge role in the determination and the outcome of this case. That's an exceedingly difficult position for us to be in, and it seems one that Rule 52A1 is entirely designed to try to prevent us from doing.
Your Honor, may I respond?
Sure, absolutely.
I'm very concerned that this is a very unusual case that perhaps shouldn't have new rules about minors' testimony created because of the very unusual circumstances here that, for all we know, Mr. Sherrill had no idea that this had happened until the testimony during the first temporary hearing. And I think that the court ought to be very careful in fashioning a rule that somehow prohibits parents of minor children from stipulating that the children can go ahead and tell their story because they believe that the child should have the opportunity to address the judge and to speak freely and fairly. And under these circumstances, the child came through with some extraordinary testimony apparently, enough to move the judge to deny visitation altogether. And from what we do know about it is the mother confirmed to the judge's satisfaction certain of the points along the way about the incident that happened in the bed, the sleeping with the mother all those years. And I don't right now remember whether she addressed, whether the court addressed the issue where the mother went back and tried to pressure the son to sleep with her again. But that sounds like that's over the line towards abuse after the child had indicated to her that he didn't want to sleep with her anymore. And then she goes and gets on the bed with him. And they have a battle, and then she takes his PlayStation away from him to punish him for not sleeping with her. Those are reasonable inferences from the record that's there, and the judge could draw those inferences and probably isn't required to set them all out in a public record that way.
If I can circle you back real quick to when we were talking about substantial change in circumstances. One thing that gets me is, some of our other cases and some focus of our question has been on things that the mother can do. That's not always what leads to substantial change in circumstance. Obviously, you mentioned if unfortunately the father were to pass, something like that. But sometimes it can involve changes with the children, improvements, degradation, different things like that with mental health, physical health, all kinds of things with the child. But it seems like even if we were to consider changes to the child and the life of the child, it feels like he was in a very positive place for the status quo at the time of the hearing, giving the results of his treatment, how he's doing in school. So could there be any substantial changes that the mother could look at with the child that are positive in nature that would give her an opportunity to reopen the door on visitation? I'm just not seeing it.
Well, I can think of something. And one of the things might be that if the child is so dissatisfied with his circumstances that he reaches out to his mother and says, "Mom, I can't stand living with Dad any longer. I've got to change something." Then the child has reached out to her because there is, in fact, a change in circumstances. And I think that that would be fair game for her to do that.
Wouldn't that be more akin to the Disney World parent situation where a teenager is fighting with mom or dad because they can't go out on the weekends? That kind of situation? Or are you talking about more, hey, there are issues of substance abuse raised with the father in the order? Or are we talking about things like that increasing? What do you really mean other than, hey, I'd rather be with you next week than with Dad?
Well, I certainly think that it would, from what I gather from this, the child was not interested in resuming a relationship with his mother because he refused the gifts, he refused the presents, he wouldn't talk to her. And if the child reached out to the mother and said, "I'd like to create a new relationship with you, Mom, can we go out and talk?" That would strike me as being the kind of change in circumstances that she would know about and that she could bring to the court's attention. For that matter, I don't know whether any of the other collateral proceedings, like in terms of child support and other things like that, it would be inappropriate for her to inquire about his grades or his progress in school and discovery and try to find out something about that from Mr. Sherrill. I don't know. And there's probably pathways that she could do it if she were determined to. But I think that the judge intended for it to be difficult for her.
Mr. McDonald, let me ask you about that. As far as a change in the future. Well, okay, with these findings under this order, the mom basically has no right to go to the school, get information, get medical records, find out what's going on. So she has no capacity to do that. So let's say that in the future, let's say that the child his performance in school has taken a downward turn, that he's failing, that he's having some serious problems. Of course, she doesn't know about that because she's not allowed to get the information. What in this order would justify preventing why would she not have access to information or even some sort of supervised visitation or some sort of way to communicate with the child in the context of counseling, or, you know, some sort of reunification therapy or something? I mean, what justifies, I mean, we see a lot of very terrible cases here, and we have basically one incident of inappropriate touching, and the mom is completely cut out. How does the order justify completely cutting her out?
Well, Your Honor, I think that it must be based on what the child said, but I also think that we should be careful not to be creating a case where there's not one. One of the things that I think that the mother might do would be to request a modification of the order on the grounds that it's been 2 or 3 years since she's seen the child. She doesn't know anything about it, and make her case how she's reformed, how she's better. And
How is she supposed to reform?
well, I have no idea, but she apparently really was not taking responsibility for what the judge saw.
We don't know what the judge said. I mean, she acknowledged that she touched him there, and she says it's an accident. Obviously, the judge thinks it's not. But you know, usually we'll have some sort of, you know, counseling or therapy or some sort of procedure to kind of deal with that. And she went to therapy. So what is she supposed to do? She did everything they asked her to do.
Well, that's true. But I think that if she wanted to bring that issue before the court for determination, she could make a motion, make her case, and if the judge denied it on the grounds that it's not a change in circumstances, then she could bring that to the Court of Appeals and argue that here. And that way, that question would be properly presented in the context of what it is that she thinks are the changes in the circumstances. And who knows, she might even be able to do discovery to request that information, and the court might give it to her. So I don't think that in the posture of this case, it's necessary for the court to anticipate something that has not been fully vetted in the trial court.
I want to take you to pages 12 through 14 of your appellee brief.
Yes.
You lay out 7 things that have not ended, that kind of separate this from a termination of parental rights case. If you were to find that we should be considering this as, you know, regarding the constitutional concerns and losing the parent-child relationship, if we were to consider it in that vein, which, if any of these things you've listed or other things that are out there that you're aware of are not just grants of ability from the state? And what I see here, 1 through 7, are all things that the legislature could go in next week and change if they wanted to. If they wanted to make inheritance go, everything goes to the Red Cross. You know, that'd be within the state's authority to do so under the state law. What things that are not dictated by statute is she retaining? So which constitutional rights is she retaining versus statutory rights is my question.
Well, Your Honor, I hadn't anticipated it. That's a very good question, because I think that in many ways, many of the parental rights are statutory. And this is a list of a large number of them, and the legislature could change those at any time. And that change in statute might violate the Constitution. If that's the case, then a proper party can bring a question for declaratory judgment to determine that. But there's no question that there are constitutional rights of parents, but our Supreme Court has made it perfectly clear and absolutely crystal clear that the constitutional rights are irrelevant in a dispute between the two natural parents. And I don't think that it's within the authority of the Court of Appeals to disregard that ruling from the Supreme Court. Now,
let me ask just before we move on, and I don't want to get too deep into civil penalties, but if it's within the authority of our court in respite to say that our court in Moore misapplied a North Carolina Supreme Court holding, would it be any different for our court or panel of our court to say the North Carolina Supreme Court and misapply a U.S. Supreme Court holding in Troxel?
Well, Your Honor, I guess that one of the things that's fascinating about this case is certainly something that has captured my imagination about it, is the number of opinions that have come out in the number of cases along the way. I frankly thought that Judge Berger forecast that the matter ought to go to the Supreme Court for resolution, because it is, at least there are arguable points one way or another about it, and the application of in-rate civil penalty is not as clear. I mean, I think it's fairly clear where we are with this, but we do have a more case that is inconsistent with the Supreme Court.
Does Moore ever reference O&B?
No, it didn't.
It's not a misapplication of O&B. It's just a failure to grapple with O&B, our Supreme Court, right?
Well, I believe that that's addressed in respite. And in respite, I think what they said was that the argument in Moore had occurred before O&B came down, and O&B came down before the decision in in Moore. So
Moore's not only inconsistent with O&B, Moore is also inconsistent with our case law pre-O&B. I'm looking at a case called Grindstaff from 2002 that talks about best interest of the child standard applies in custody disputes between parents. An opinion written by Judge Tyson in 2002, the year before Moore came out. So it seems to me that Moore actually has an in-rate civil penalty problem with things like Grindstaff and things like cases like Sharp that already seem to indicate, what you said about O&B, which is that the protected status is irrelevant when we're dealing with a custody dispute between parents, right?
I agree, Your Honor. And I love the constitutional law, but I think it's as important to recognize when the constitutional issues are not present in the case as it is when they are.
And if we were, say, sitting here and looking at cases that may not have incorporated Troxel versus Grandville, and where the phrase parent is used singular in addition to where it's used plurally, would we be free to say that our court may have misapplied that because they weren't referring to the right part of Troxel, or disregarding Troxel versus Grandville altogether? Singular parents right versus the often quoted portions regarding parents plural.
I'm not prepared to address that, Your Honor. I regret that that argument came in. I looked at Troxel in advance of this, but I'm not prepared to address that particular point about it. But it's clear that the state's constitutional right to interfere with the family is called into question when the child is being taken completely out of the nuclear family, the natural parents or the adopted family. And that's what happens.
Mr. McDonald, since your time's up, I'll just let you sum up briefly, like within a minute, and then we'll move on back to our rebuttal.
All right. I guess there is one issue here, and that I would like to be sure that I have addressed, and that is that here the trial judge made a conclusion of law that Mrs. Sherrill was not fit. I think, and opposing counsel correctly pointed out that I did not make a citation to authority for the position that it's that it doesn't matter. I have authority to that effect, that a mischaracterized conclusion of law or a finding of fact is inconsequential. I would like to have the opportunity to submit a supplemental authority on that, if I may have permission to do that.
I will say, Judge Stroud, if we could withhold any additional authority just given the status of Bruton at the Supreme Court, there may be
That's true.
a chance that we might additional authority.
I think that'll be all right. Okay. All right. Well, thank you, Mr. McDonald, for your argument. And we'll move in. Like I said, we gave Ms. Cannell additional 4 minutes since we asked so many questions.
Thank you very much.
Am I unmuted?
You are unmuted.
Thank you again for the opportunity for a few extra minutes. I just want to point out 3 things in rebuttal. First of all, counsel stated that these are unusual circumstances and that this court should not make any decisions based on this particular case with the conversation with the minor child and Chambers. And to the contrary, and I sort of hesitate to bring up more at this point, but just not looking at the standard of review. The facts of the case are very similar and more in this case, where there was a child who said, my dad did this sexual act, and the father was then investigated by police and DSS, and psychologists testified, and they found that nothing had happened. There was no evidence of any sexual misconduct. And the trial court said, I'm still denying dad visitation. So this is not an unusual situation at all, where a child will testify to one thing or say one thing, and then all the evidence to the contrary after investigations.
Can you briefly just respond? Mr. McDonald made a series of points that are well taken in regards to the sensitivities around minor testimony and how that was, efforts to safeguard minors' privacy. Do you want to respond to any of those?
Absolutely, and that was my second point, so thank you, Your Honor. A child, he stated that the child could speak freely and clearly. Your Honor, that's what a guardian ad litem is for. There are plenty of avenues for a child to have a representative to speak for him. That's exactly why those are in place. And a court could have appointed a GAL in this situation. The child could have talked to DSS in this situation, and that was not done. And then the adults could come in and testify. I recommend that my clients take their children to counselors and speak to the counselors, and then the counselors can come in and testify on behalf of the child. The third point that I want to make is about 50-13.7a, and that specifically talks about a substantial change of circumstances. And Your Honor, the case law states that permanent custody orders is sort of a misnomer. Custody orders are never permanent. The court can always go in and revise and modify because we're looking at the best interest of the child. However, there are specific criteria that you have to make. So when someone comes to me and say, I want to modify custody, we look at everything that's happened from the date that the order was entered to the point that we're going to make this modification. And if there's no changes in that, we can't just say, well, you haven't seen the son. And so we think that maybe there's been a substantial change of circumstances. I would be afraid of a Rule 11 at that point. So I think that there needs to be established what happened in the permanent custody order in order for mom to come back in and say, this is how it's been changed. But she either can't change because it deals with her and there's nothing for her to change, or she doesn't know. I also think that it's unrealistic for us to believe that a minor child whose whole world is their father, who has, the only person he's seen for 3 years, to go and say, to call his mom and say, hey, I'm calling because I want to have a relationship with you. I just don't think that that's realistic. And I don't think that's what minor children should be doing. I think that does exactly what the trial court says and puts the child right in the middle of this custody argument. And I will end with this. And again, it's a U.S. Supreme Court, the Santosky case. And this is what I just want to point about, and because this is really at the heart of this. And the court, it states that parents normally love their children and desire not only what is best for them, but also for a deep and meaningful relationship with them. Therefore, the decision to remove a child from custody of a natural parent must not be lightly taken. And that's where we are, Your Honors. And I appreciate so much you taking the time to want to look further into this case. And I appreciate you dealing with my technology issues. or lack thereof.
Let me ask just one question, and maybe this is going to be more rhetorical given the amount of time we have left, but Judge Berger's concurrence in the written case, talks about our back and forth and in civil penalty issues. And, it has the line, through our frequent intramural disputes over in civil penalty seem significant to us, the underlying legal issues are often narrow, of no public interest. At what point do our intramural disputes become equal protection violations? When you have one party coming to the North Carolina Court of Appeals and getting one standard review on the potential loss of their parental rights, and one parent comes up and we deal with it on basic child custody issues. At what point does an internal split like this become an equal protection issue? And maybe I'm sure that might not be something you thought of, but I just want to maybe raise that as a rhetorical concern and give you a chance to respond.
Your Honor, that is far beyond my intellect but I would love, this court has been put in a position for the years that you are making decisions about these child custody cases. And I don't know how to say that they can be rectified. And especially with child custody cases, that every case is so different. So I apologize that I don't have an answer for that. But I sure would love one.
All right. Well, thank you very much to everyone. Maybe the Supreme Court will give us some answers on some things someday. Anyway, thank y'all very much for your arguments and with your putting up with our, I think this is our third WebEx argument that we've had at the Court of Appeals. So we're learning. And thank you for your arguments.
Thank you very much, Your Honor.
Thank you.
And we are adjourned.
This session of the North Carolina Court of Appeals is now adjourned.
Good to see y'all. Thank you so much for your argument.
Thank you very much, Your Honor.